All right, everyone. If you're going into law, getting your head around copyright is, well, it's not optional. This is the bedrock that protects creative work, everything from movie scripts to software code. So today, we're going to roll up our sleeves and really get into the nuts and bolts of India's Copyright Act of 1957. Trust me, this act is going to be a close companion for many of you in your careers. Okay, so here's our game plan. We'll start with the basics, what copyright actually is. Then we'll jump into what rights you get as a creator. We'll cover who owns those rights and how they can be transferred, and then get into the really meaty stuff. What happens when someone copies your work, infringement, and the big exception, fair use. We'll wrap up by looking at how you actually enforce these rights. So picture this. Your future client walks into your office. They've just finished writing a novel, composing a song, or building an app. They've poured their heart and soul into it. Their first question to you is going to be, what now? How do I protect this? And that is exactly what copyright law, specifically the 1957 Act, is designed to answer. Okay, let's start at square one. Before you can even think about building a legal argument, you have to know exactly what we mean when we say copyright. So, here's the key thing to remember. Copyright is a legal right. It's not just a nice idea, it's spelled out in the law, the Copyright Act of 1957. It covers all sorts of original works, books, music, art, you name it. And here's the magic part. Protection is automatic. The second you write that song down or save that document, boom, it's copyrighted. You don't have to register it for that protection to kick in, though. As we'll see later, registration is a very, very good idea. Now, this is probably the single most important concept you'll need to grasp. It's called the idea-expression dichotomy. Copyright doesn't protect a general idea. So the idea of a boy wizard going to a magic school, that's not protected. Anyone can write a story about that. But the specific story of a boy named Harry Potter with his friends Ron and Hermione, the specific plot points, the exact words on the page, that's the expression, and that is what's protected. Getting this difference right is absolutely critical because it's at the heart of almost every copyright dispute. Okay, so your work is protected, great. But what does that actually mean? What powers do you now have? The law gives the creator what we call a bundle of exclusive rights. Think of it less like a single key and more like a whole key ring full of different keys. Each key unlocks a different power over your work. You'll find this list of powers in Section 14 of the Act. And here's what's so useful for us as lawyers. These rights aren't an all-or-nothing deal. You can give one key to one person and another key to someone else. They're divisible, which allows for all kinds of specific deals and contracts. And just look at what's in this bundle. You, and only you, get to decide who can make copies of your work. You control who gets to sell it, who can perform it in public, or who can turn your book into a movie. Want to translate it into another language? That's your call. Each one of these is a separate right that you control. This is where the real economic value of copyright comes from, that exclusive control. Okay, so this bundle of rights is actually split into two types. First, you've got the economic rights. These are the ones you can sell, license, and basically make money from. But then you have something else, something really personal, moral rights. You'll find these in Section 57. And you can't sell these, ever. They stick with the creator. This includes the right to be named as the author, that's the right of paternity, and the right to stop someone from butchering your work in a way that harms your reputation. That's the right of integrity. This all naturally leads to the next big question, and it's a super practical one you'll face all the time. Who actually owns all these rights? And can you give them away? Well, the starting point, the general rule in Section 17, is exactly what you'd expect. It's simple. The creator of the work is the first owner. You make it, you own it. Easy enough, right? Well, hold on, because in law, it's the exceptions that always trip people up. And Section 17 has some big ones. For instance, if you create something as part of your job, say you're a journalist writing for a newspaper, your employer probably owns the copyright, not you. Same goes for some commissioned works. If someone pays you to take a photograph, they might be the first owner. The big takeaway here? Always look at the contract. That's where the truth usually lies. So when you do want to let someone else use your rights, there are two main ways to do it: assignment and licensing. Think of it this way. An assignment is like selling your house. You transfer ownership, sign the deed, and it's not yours anymore. A license, on the other hand, is like renting out a room in your house. You still own the house, but you're giving someone permission to use a part of it for a specific time. Getting this distinction right is huge for your clients. It completely changes the deal. All right, let's get to the conflict. What happens when someone uses your work and you didn't give them permission? Now we're talking about infringement. But we also have to talk about its flip side, the most important defense, fair use. Infringement is, on the surface, pretty simple. Section 51 lays it out. Basically, if someone does something that's in your bundle of rights without asking you first, that's infringement. They copy your book? Infringement. They play your song on the radio without a license? Infringement. It's stepping on one of your exclusive rights. But it's not quite that simple. The law recognizes that society needs to be able to use creative work sometimes for the public good, so it carves out some exceptions. This is where the doctrine of fair dealing comes in, which you'll find in Section 52. It basically says, okay, even though you didn't get permission, it's okay to use the work for certain things, like criticism, research, or news reporting. So how do you know if a use is fair? Well, our law in Section 52 is a bit more specific than, say, the American system. First, the use has to be for one of the purposes listed in the law, like research or commentary. But even then, a court will look at a bunch of factors to decide if the use was truly fair. They'll ask questions like, why did you use it? Was it for profit? What kind of work was it? How much of it did you take? And maybe most importantly, did your use hurt the creator's ability to make money from their original work? You absolutely have to know this framework to analyze any infringement claim. Okay, so let's bring this home. Infringement has happened. Now what? Who do you go to, and what can you actually do about it? Let's talk about enforcement. There are 3 key players you need to know in the Indian copyright world. You've got the Copyright Office, which is where you go to register your work. Then there's the Copyright Board, which is like a special court for settling copyright fights. And finally, you have copyright societies, which are really cool. They're groups that help creators manage their rights and collect money so they don't have to do it all themselves. Remember how I said protection is automatic? That's true, but you should still tell every single client to register their work. Why? Because that registration certificate is like a golden ticket in court. It's considered prima facie proof of ownership. That's a fancy legal way of saying the court assumes you're the owner, and it's up to the other guy to prove you're not. It flips the burden of proof, which is a massive advantage in a lawsuit. It is a critical step. And when you do go to court, you have some powerful weapons. The law gives you 2 paths, civil and criminal. On the civil side, you can get an injunction. That's a court order to make them stop. And you can sue for money, either damages or the profits they made. But the act also has teeth on the criminal side. We're talking potential jail time and fines. That tells you just how seriously the law takes protecting creative work. So there you have it, the core principles of our 1957 Act. But I want to leave you with this thought. As you start your careers, you're stepping into a world where these rules are being pushed to their limits every single day. Think about it. Who is the author of a piece of art created by AI? Is a viral meme that gets remixed 1 million times a form of fair dealing? These aren't textbook questions anymore. They're the real-world challenges that you, the next generation of lawyers, are going to have to figure out.